Mishcon Academy digital sessions.
Good afternoon, everybody, and welcome to this Mishcon Academy digital session on the FCA Business Interruption Insurance Test Case litigation. I'm Miles Geffin, and I'm moderating this event. I'm delighted to be joined today by Sonia Campbell, Richard Leedham, Ben Lynch QC, and Ralph Fearnhead. So we're going to begin with a discussion around the test case and its implications for policyholders and for insurers. Richard, can I begin with you? Would you just kick off with a brief overview of the test case?
10 months or so ago, COVID obviously hit for the first time, and the government imposed all the various restrictions on us. Very quickly led to a lot of claims being made under business interruption insurance policies, and insurers pretty quickly took a view individually, one has to say, but it was the same view pretty much from all of them, that claims weren't going to be paid out. The FCA, having already written to policyholders and to insurers trying to sort of generate some momentum, came up with this plan of using the hitherto, I think, almost completely unknown financial markets list process to bring this test case, cajoled one on our side, we don't know, 8 insurers into doing that. We inputted the selection process of policy wordings, and so wordings that Sonia and I and our teams were advising on were included in that case. And the case was run as a test case in the commercial court. It was felt helpful to have a policyholder view at the table, as it were, and Ben made submissions for us, as did Sonia's counsel, Philip Eady, in the first instance case, to support the policyholder's position.
What I'd really like to do is just touch briefly on the different categories of wording. And you'll see the third bullet point down, those 3 categories: disease clauses, preventive access / public authority clauses, and hybrid clauses. Disease clauses, in large part, do what they say on the tin. They are clauses, these are described, helpfully summarised, paragraph 4 of the Supreme Court's judgment. Clauses which in general provide cover for business interruption losses resulting from the occurrence of a notifiable disease, such as COVID-19, at or within a specified distance of the business premises. Classic disease clause wording: we shall indemnify you in respect of interruption or interference with the business during the period following any occurrence of notifiable disease. And you'll see ones at the premises, you'll see ones within a radius of 25 miles. This was the hybrid wording, the Hiscox hybrid wording, and you'll see why it's called hybrid, because it's got both the disease element and preventive access or inability to use elements.
Sonia, following on from Ben's overview and from what he's just said, what are you now seeing practically on disease and prevention of access wordings?
In practical terms, I think where it leaves people with disease clauses is if you have a geographical radius limit in your policy, and you can show a single case of illness sustained before the relevant government restrictions, then you should be, and there's a case in your radius, then you should be able to claim cover from your insurers. And we are seeing, for insurers who are not part of the test case, that they are, in certain cases so far, abiding by that decision. So hopefully others will follow in the spirit of what the FCA has expected and what the judgments expect, that they will do so.
It's not often, in fact, I'm not sure it's ever happened before, that you've had a regulator taking the companies that regulate court on behalf of their own customers and making arguments for them. So, just in terms of the end of the case, you had the Financial Conduct Authority, you had 8 of the insurance companies it regulated. You had 2 groups of intervening policyholders represented by Mishcon. There were actually 2 other groups that tried to intervene at various points and were told by the court that it wouldn't be appropriate for them to do so. So huge numbers of parties. You had 2 case management conferences which were held before the first instance trial. That lasted 2 weeks. Involved both a High Court judge and a Court of Appeal judge. They then produced a detailed judgment. They then produced a set of declarations which were anticipated by the FCA at the outset, and were really there to try and provide a helpful guide for people to interpret the judgment and for solicitors to look at when actually assessing claims, whereas the normal process would involve the High Court, then the Court of Appeal, then the Supreme Court. In this case, the proceedings went straight from the High Court to the Supreme Court. They did so incredibly quickly. We had a 4-day appeal held in the Supreme Court. They produced a very detailed further judgment. Ben's mentioned how many documents there were. Literally tens of thousands of pages of evidence. Over 1,000 pages of legal submissions. This was all held entirely remotely. So, there was never anyone physically present in a courtroom. As with everything due to COVID, we're now used to this. But, going back to the time the case was heard, this was, something which I don't think any of us could have imagined happening 18 months ago before we came into this world. And so you've had, 2 very serious court cases with huge numbers of parties, huge numbers of documents, all held remotely, all streamed over the internet, and it's all happened, pretty seamlessly.
Some say that these policies were never intended to respond to pandemics, and therefore the court has had to sort of play around with causation to reach a result. Personally, I don't agree with that. The proper approach to the construction of a policy is you look at what it says, and you don't look at it with the benefit of hindsight. But there are plenty of authorities, and it's a point that we made in arguments, which is there's a well-known case called Bromerin, which was then considered by Lord Justice Leggett, as he was then in the Aquitas case in the Court of Appeal, which says that what you do is you look at the wording as a reasonable, objective person, i.e. standard approach to construction, at the time of the events, even if those events were not foreseen. So foreseeability or otherwise isn't really the touchstone of construction.
In light of this, in light of the decision, in light of what the Justice said on the causation point, what's actually happening on the ground now with claims?
The Supreme Court case, as we said from the outset, didn't actually consider the claims of any individual policyholders. It considered the arguments being made by the insurers for denying claims, and it's held very clearly that in a large number of cases, the arguments being made by insurers to deny the claims were wrong. So the question is, having been told that they denied the claims wrongly, what should insurers now be doing in respect of those claims? And the FCA has said consistently, and it's reiterated this following the judgment, that they should now be writing to all their policyholders, writing to all their brokers, telling everyone concerned with these policies that they are now reconsidering them and that they are reviewing them, and that some of them may now be covered, even claims that they were previously denied. And where that is the case, then it's been made very clear by the FCA that insurers should be acting very quickly. They should be telling people they do have cover. They should be moving very quickly to adjust those claims, work out the quantum of the loss. But also, importantly, while they're doing this, because a lot of these businesses have been really badly affected, they should be making interim payments. As soon as they establish cover is still there. It's been almost 10 months to the day from when the Prime Minister first announced the first set of COVID restrictions in the UK, and bar a few exceptions, most people who put in claims who had this cover have yet to receive any money. Now, in that intervening 10 months, it's been a very difficult time for businesses. Many have had to lay off staff. They've been unable to afford to keep on their premises. They've been doing what they can to meet ends meet, and sadly, some haven't been able to. Some have gone into liquidation. We have, half a dozen clients in the group of Hiscox policy holders we represent for whom 10 months was just too long, and they're no longer there.
It's a live issue in our ongoing claims with Hiscox, and to be clear about that, those are in arbitration. That is a matter of public record. It was mentioned by Hiscox's counsel in the Supreme Court hearing, but obviously I can't say anything more about that, and it is a live issue. I think, stepping back from the arguments we're running, one can see that, of course, there are certain policies that were argued over before the Supreme Court, and not the Supreme Court, the first instance court, that insurers won on. And they will say, well, it was entirely reasonable to run arguments that we did. We won on some of the points, we lost on others. And you, Mr. Policyholder, haven't got a complete home free run on absolutely everything. And it was right for us to fight those cases. And that's an argument we're going to have to deal with, because it's not as if it was a one-off case. one policyholder against an insurer. As I said earlier, policyholders weren't involved in the case apart from anything else, where the defendant insurer was found to have behaved unreasonably and should have paid the claim from the very beginning on points of principle. But I think against that is you've got sort of fundamental principles of English law that when a judgment comes down on a case, that is how the law always was. And it does give you the starting point to say, well, okay, and I think where this will go will be on, and Ben alluded to this earlier on some of the wordings, as we had clients at the very beginning saying to us when they came to us, saying, look, this must be covered. I don't understand what Hiscox is saying, coupled with various examples of having been told as they were buying the policy, just as the COVID restrictions, the restrictions weren't happening, but COVID was hitting, yes, this will cover you for this type of loss. And then they fight through, as Ben was saying, we ended up with thousands of pages of documents, 3 weeks of court hearings, 3 or 4 other interlocutory hearings, to be told in no uncertain terms, if you read the judgment of Lord Briggs tucked away at the end of the Supreme Court judgment, it's a brilliantly devastating critique of insurers' overall attitude towards these claims.
Where for disease clauses you have a specific list of diseases which doesn't include COVID, and it won't, because your policy would have been in place before COVID was known about. COVID became a notifiable disease on the 5th of March for our purposes. If you have a list that just lists diseases, or it says notifiable disease and then notifiable disease is defined as a specific list, that's called a closed list. And you won't have cover under that policy unless it has additional wording that says, or any other disease that becomes a notifiable disease, etc. So where we're getting a lot of questions about, well, I've got disease cover, but they're saying I'm not covered, quite often it's because of that reason.
The last 10 months in the insurance context here have completely polarised opinion. You've got policyholders, and yes, we represent them, we're on that side of the fence, think insurers should put their hands in their pockets very quickly, when everyone else was, to some extent, particularly sort of government. We all had to adapt and do different things, and they were seen as not doing that. The insurer side, and one of the questions, well, they weren't intended to cover pandemics, they weren't designed for this. Those wordings were certainly historically aimed at localized shutdowns of businesses for sort of local disease or bomb scares or whatever. But the fact is that has been fought out in the most serious way possible before now 7 very senior judges who have all found that those arguments aren't right. The underlying arguments on causation, intent of the policy, the intent of the policy never even really came up in any of the legal debate. It was what we thought sort of underpinned insurers' arguments on causation. They were trying to argue something to demonstrate that they hadn't intended to pick up these losses. The court's been clear about that. Of course, on particular wordings, as Sonia has said, there'll be uncertainty. They've won on some of the wordings. They've clarified that. It really is time for them to step up, pay the businesses that they should pay, read the Dear CEO letter, make the interim payments that need to be paid, whilst the more complex issues of adjustment. There's no one saying BI losses, even for small businesses, are necessarily straightforward. They need to be adjusted, but money needs to start flowing from the insurance industry, who receive billions of pounds of premium. I'll just end on one stat I read. They've saved £4 billion. I don't know if that's globally or just in the UK, from not paying out on motor claims because of the lack of motor accidents during the pandemic. If that figure's accurate, they've got the money to pay these claims. They should be paying them.
The clients that we've all got, many of their policies have come up for renewal during this period, and I haven't seen one policy that doesn't have an exclusion for contagious or infectious diseases. I don't know if anybody's got a different perspective where they have seen that cover continue, but these policies, in terms of how they operate, it's very clear now that on renewal there won't be cover, in my view. Recently,
just one example, Ireland has delayed their proceedings to look at our Supreme Court judgment, I read recently, but there are plenty of others happening all around the world, and it may be that our Supreme Court judgment is regarded as helpful for assisting determine those disputes, but it may not be, because the law is so different in those areas. So obviously it'd be a matter of where the insurance is being provided.
All that remains is for me to thank our panellists for what I think has been a very lively and energetic discussion. We hope to see you all very soon in the future Mishcon Academy digital sessions. So thank you and goodbye.
The Mishcon Academy digital sessions. To access advice for businesses that is regularly updated, please visit mishcon.com.